What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly Case Update. It's a Tuesday, which is normally not the best day of the week, but I'm going to try to make it a little bit better with a case law update. I got 3 interesting cases for you this week. The first one is dear to my heart because I am a Florida State Seminole grad for undergrad. This is Atlantic Coast Conference versus FSU Board of Trustees. This, I don't know if you've heard it in the news, but this has to do with Florida State's lawsuit against the ACC trying to break out of the ACC. And so this is a case involving principles of comity, not like ha 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 comedy, but COMITY. And basically that has to do with which jurisdiction is going to take jurisdiction. Usually the jurisdiction that assumes jurisdiction, I'm saying the word many times, is the one that gets jurisdiction first. And in this case, that happened to be North Carolina. So apparently what happened was FSU made it clear because they had to in a public announcement that they were going to file a lawsuit because they needed to get approval from their board. So they made it clear that they were going to file a lawsuit against the ACC. So what did the ACC do? Well, the very next day, the ACC filed a lawsuit in North Carolina, basically trying to get ahead, trying to get a head start on Florida State's case because they knew that Florida State was going to file here in Florida, and they figured they'd probably get a better shot in North Carolina. Maybe in Florida courts will give them home field advantage, so to speak. So anyway, the ACC moved to dismiss the case or to stay it pending the resolution of the case in North Carolina. And the trial court in this case, which is in I guess it's the state courts in Tallahassee, is the first DCA case. The trial court denied the motion to stay and said, look, even though normally the first court to assume jurisdiction is the one that has priority, which is the term that they use, priority in comity, the state that exercises jurisdiction normally has priority, and that's North Carolina. However, it's not necessarily like a per se rule where the first state to get jurisdiction has to proceed with the case. And so there are exceptions. And one of those exceptions is what the court calls an anticipatory filing. And so that's exactly what happened here. The court in North Carolina got jurisdiction only because the ACC kind of, tried to pull a fast one, so to speak, and got an anticipatory filing first, 1 day in advance of Florida State's filing here in Florida. So the court denied the ACC's motion to stay the case. And so the case, ostensibly, the case in Florida will proceed. So we'll see what happens. This is the one over whether Florida State can get out of the ACC and get out of that contract where they essentially assigned all their media rights to the ACC, to the conference. So we'll see how this unfolds. But exciting news. And an exciting case to follow, especially as a college football fan and as a Florida State fan. Next case is a couple more family law cases, back to those. This one is AA versus MA. These are initials because this was also, it was a divorce, but also a dependency proceeding. So they do the initials in those cases. This is out of the second DCA. It has to do with imputing income. And so in this case, it's interesting that the wife must have been some sort of an alcoholic, unfortunately. And so, but at one point, 4 years ago, she was earning $110,000 a year in a job. However, that was a job that was out of state, not in Florida, not in the geographic location where the case was pending. And it was 4 years ago. And the thing was, there was no other evidence to go off of to show what her current income was. So the husband apparently tried to impute income to the wife and say, okay, she's able to make $110,000. She was able to do that 4 years ago, albeit out of state and so long ago, but she's able to make that money. And so the appellate court said, no, that's too far in the past for the information and the evidence of her income in order to impute income. Remember, to impute income, it's a 2-step process. First, you have to show that the person is voluntarily unemployed or underemployed. And so the court said, well, here she may not even be voluntarily unemployed because she's an alcoholic, and if alcoholism is like a disease, it's like a sickness, is she really voluntarily unemployed? Maybe not. But either way, there was no evidence. There's no competent, substantial evidence of her ability to make that much money anyway. So the court said, look, you can, if, in that situation, the statute allows you to impute income based on the median income level as determined by the U.S. Bureau of Statistics, the U.S. Census Bureau. So if all else fails, you have no other evidence, just go under the median income pursuant to the U.S. Census. That may not be a lot of money compared to what the former wife or the wife could make, but it still allows you to do that. Last case is a pretty simple one. It's out of the 4th DCA, Domnin versus Domnina, and this one has to do with due process. And this happens sometimes in these temporary support hearings, temporary attorney's fees hearings. Courts want to make it fast, right? And so what happened was the court apparently ruled on the temporary award, temporary alimonies and attorney's fees, right after the movement made their case, didn't allow the other side to make their case in chief. So remember, even if you're the one that's moving for fees or moving for a temporary alimony and the court's gung-ho about giving it to you, you may want to take a step back, pump the brakes, and just allow the other side to put on their case, because otherwise that's going to get reversed on appeal. That's a violation of due process if you don't let the other side put on their case in chief. All right, guys, that's it for this week. I hope you all have a wonderful week. I'll see you next time. Take care.